I am really thrilled to be introducing a close colleague, Dr. Rajan Moon. Dr. Rajan Moon is our Associate Director of Education for the Center for Healthy Aging and Innovation. He's also the Faculty Director of the Long-Term Care Administration Program in the College of Continuing and Professional Studies. They've changed the acronym in the name, so I'm trying to remember. Dr. Moon is known as a leader in long-term care in the state of Minnesota. He was the executive director of the Minnesota Leadership Council on Aging. For those of you that aren't familiar with the MNLCOA, it's really the premier organization that brings all of the major organizations focused on aging services and supports together at the same table. And MNLCOA is probably the leading advocate organization, the leading organization in ensuring that the services and supports provided to older people and their families in the state of Minnesota remain so highly regarded, which they are. And so Dr. Moon is going to be giving us a very timely presentation called Taming the Wild West, Minnesota's new assisted living law and what it means for you. So please join me in welcoming Dr. Moon. Thanks, Rajan.
Thanks, Joe, and good morning, everyone. It's a little bit of a surreal experience here, being in a room for the first time, being back at the university, after 15 months. The university does have a certain smell to it, the buildings, and when I walked in the McNamara Alumni Center here this morning, I took that first deep breath and could smell that academia, which is pretty wonderful. The campus is quiet today, as it usually is in the summer, but especially with our current situation, is extra quiet. I do want to send out thank you to Dr. Gogler and his team, including those that are here with us, making sure that all the tech, all the IT works out, and we're able to present this information to you. So it's pretty amazing being fully vaccinated, being in a room that fits several hundred people, and there are 5 of us. So I'm imagining all of you at home sitting, having your cup of coffee, perhaps in your pajamas. I managed to get myself out of bed this morning, and for one of the first times, get dressed, get in the car, and come to work. So very happy to be here today. As Dr. Gogler said, I'm very happy to be part of the team at the Center for Healthy Aging and Innovation, where I primarily focus on our education initiatives, working with students in our graduate minor in gerontology, implementing a webinar series for professionals on different applied topics in aging, and another special project, our Age-Friendly University project. The University of Minnesota is the first college or university in the state to enroll in the global network of age-friendly universities. And that enrollment is a commitment by our university and our university's president to move forward, ensuring our organization reaches out through the generations to welcome older adults, lifelong learners, and retirees to our campus, to use our resources, leverage our resources, and to ensure that we have intergenerational dialogue with our students and our faculty and staff. We also have an important role here at the university in assisted living. We are one of the very few state accredited programs to offer the required training for those who want to become a licensed assisted living director. And I'll be talking a little bit more about that in my presentation, that now we have a new professional license for individuals that are overseeing assisted living facilities. As Joe said, please do feel free to ask questions. I'll be using some technology myself here with my phone to see any questions that appear. I promise I'm not checking any sports scores or doing any online slot machines or games. So do bear with us with the technology. And again, thank you to the people that are helping us be very successful in our technology today. I also just want to say that I'm not an attorney, so I'm not here providing legal advice. I'm really offering insight to you, individuals that are caring for people with memory loss, those of you that are living with memory loss, and the professionals that support both family and friend caregivers and individuals, to talk a little bit about the statute and the rules that have come forward in recent legislation and a rulemaking process that have really completely altered the landscape of assisted living in our state. So I really have 3 objectives for my presentation this morning. It's to understand the context around the regulatory reforms. And when I use the phrase regulatory reforms, I really refer to any rules and license changes that have occurred. For those of you like me who are really policy wonks and do spend time reading statute, I'll also cite the state statute as much as possible through my presentation. I'll be referring to something called 144G. That is a chapter in state statute that the assisted living is now currently under. I'll also talk about how the regulatory reforms impact persons with memory loss and caregivers. And then I'll talk a little bit more towards the end about the timeline for implementation. We are now in June, time is flying by, and the new assisted living license is coming up very quickly. We will have new assisted living facilities starting August 1st and assisted living directors by July 1st. So very quickly this summer, there'll be lots of changes to our landscape. So I wanted to talk a little bit about some of the reporting of maltreatment of vulnerable adults in licensed and registered settings. I'm not going to touch a lot on this topic. We have the World Elder Abuse Awareness Day coming up that covers a lot of information about elder justice and elder abuse, but I'm going to be referring to this throughout the presentation. And a lot of what happened in the assisted living regulation over the last few years occurred because of some of the fractured and perhaps broken systems that we have to report and investigate the maltreatment of vulnerable adults in our registered and licensed settings. So if a person has had suspected maltreatment, essentially what should happen in the ideal situation is that there is a report to what we informally call the MARC, the Minnesota Adult Abuse Reporting Center. This is one place where all reports of vulnerable adult maltreatment go to. That MARC entity then triages the reports that come in and determines, is this maltreatment that occurred in the community, which then they may reach out to Adult Protective Services within a county office, or is it something that happened in a registered or licensed setting? If it is in one of those settings, suspected cases are sent to the Office of Health Facility Complaints, OHFC, and I will also try my best to not use jargon and acronyms and use the full phrases as much as possible. These suspected cases are then triaged by the Minnesota Department of Health. And if they found perhaps evidence, they may send out an investigation team from the Department of Health to a facility to do an on-site investigation. So this is generally how the process should go and is currently going fairly well in our system. But as I'll talk about in just a minute, has not necessarily always been that way. So in early 2017, the Office of Legislative Auditor was mandated by the state legislature to conduct an audit of the Minnesota Department of Health's Office of Health Facility Complaints. And as I said, the Office of Health Facility Complaints is charged with surveying healthcare facilities and investigating these suspected maltreatment incidences. The Office of Legislative Auditor report showed that there really were systemic failures in the Office of Health Facility complaint process and investigations. And they further investigated the causes, offering numerous findings. Some of those findings included delays in investigations and missed timelines, a lack of communication to families and providers about the investigation process. It really was a paper-based system, which was not very effective or efficient for investigators or those who have made reports. There were staffing, management, and morale concerns in the Office of Health Facility Complaints at the Minnesota Department of Health. And at that time, there was a triage backlog of around 2,300 cases, which now was cleared, that initial backlog, in early 2018. And there was an investigation backlog of around 1,800 cases, and that was cleared in August of 2018. In addition, attention was drawn to the topic of maltreatment by the Star Tribune in a series called Left to Suffer. The Star Tribune series, Left to Suffer, sorry about that. I'm figuring out the technology. There we go. The Star Tribune series Left to Suffer was published on November 12 to 16, 2017, and it provided a troubling look into elder abuse in Minnesota's formal license settings, as well as really inconsistencies in those systems that were designed to investigate the reported instances of maltreatment. And I think we all can agree that the maltreatment of vulnerable adults, whether it's abuse, neglect, or exploitation, is unacceptable. And as Minnesotans, we must always do more to address the issue. Sadly, elder abuse and maltreatment occurs in every community in Minnesota, and not just formal licensed settings like nursing homes. In fact, national studies show that up near 60% of reported maltreatment of older adults is perpetuated in communities and by people that the older adult knows. What is important to understand is that the regulatory reforms really focused on the licensed registered settings, specifically assisted living. And so this media attention further pushed the need for regulatory reforms. So in December 2017, Governor Dayton formed the Elder Abuse Consumer Working Group. And this group included organizations like AARP, the Minnesota Elder Justice Center, Legal Aid, and Elder Voices, which was a newly formed coalition of family caregivers. At the same time, the Commissioner of Health resigned, and Jan Malcolm was appointed the new Commissioner of Health. And many of you may recognize Jan Malcolm. We have our consistent updates on the COVID pandemic, and they are often led by Commissioner Malcolm. The working group solicited feedback and developed a report, and this report really served as a basis for legislative proposals during our 2018 legislative session. So to go back in history, the session ended in 2018 with what was called an omnibus bill. Some people called it Omnibus Prime. Basically, all of the policies were entered into one big bill and sent to the governor. And at the time, Governor Dayton vetoed that bill, citing that our state's constitution says that bills really need to have a single purpose, and tucking so many things into one bill makes it very difficult for the governor to be able to act on individual priorities that his administration has. So the assisted living reform during 2018 didn't pass, it didn't go through. However, throughout the remainder of 2018, the Minnesota Department of Health convened 6 stakeholder groups that included consumer advocates and providers to come to consensus on the new legislation. That legislation was introduced in 2019 and was signed into law by Governor Walz. While widely agreed upon and fairly comprehensive in nature, there were some details that were left to what's called rulemaking. So the stakeholder involvement and work is nearly unprecedented. It shows in the 108 pages of legislation related to the new assisted living law, bringing together consumer advocates and providers to really hash out many of the details in the new assisted living law. In fact, Commissioner Jan Malcolm has said that this is a remarkable consensus agreement on reforms to strengthen protections for elders and vulnerable adults in Minnesota. We have a very sensitive clicker, which is good, but so I'm going to talk a little bit more about the regulatory framework, and specifically I want to provide a little bit of a background again, that when we're thinking about the regulatory framework, we're really talking about 2 different things. One is the statute. These are the laws that were passed by the legislature and then signed into law by the governor. These are codified. You can see them on the state legislature's website through the Office of Revisers. And the second part of the regulatory framework include rules. So rules are really administrative rules that are developed by the Minnesota Department of Health. So I'll give you an example. In statute, perhaps the legislature will say that a state agency needs to set fees, but they don't say the fees in the actual statute. So that state agency, like the Department of Health, then will create a rule, and often that rule is created by stakeholder input, asking consumer advocates and providers their thoughts on what a fee may be. And those become codified then in state rules, and there is a long process, public process of comment before rules are finalized and published. So I'm, again, going to be talking a bit about statutes and rules today. So the fundamental question that's answered by the regulatory framework is, what the heck is assisted living? Well, currently in Minnesota, everything that you see on your screen here is marketed as assisted living. These images were obtained merely by searching assisted living in Minnesota. In practice, assisted living is a market term that's used to describe any type of housing establishment that provides some kind of services. So it's sort of between the independent senior housing and, say, a nursing home. Everything between that is often referred to as assisted living. These establishments that you see on the slide include Luann's Place in Eden Prairie, which is more of like a home setting. Keystone Bluffs in Duluth, which is often what people think of when they think of assisted living. Sagewood in Woodbury, Brookside in Montevideo, and Kenwood in Minneapolis. You can see where there's some confusion. Certainly Luann's Place looks very different from Brookside or Kenwood. So the current licensing framework for assisted living in Minnesota is bifurcated. It's split in two. A provider offers services under a service contract with an individual. These services are regulated under a home care license or a housing with services contract through the Minnesota Department of Health. You pay for these services primarily out of pocket. So you would write a check every month for the services that a person receives in assisted living, or perhaps your income and assets make you eligible for a program such as elderly waiver, which will help pay for customized living in a housing with services establishment. A provider also operates a housing establishment, and that housing establishment is regulated under current landlord and tenant laws, our various fair housing laws, and our state and local ordinances. It's no different from anyone having a rental agreement for an apartment. The difference is these settings can include places like board and lodges, apartments, adult foster cares, boarding care, a whole number of types of buildings as shown on the previous slide. You pay for these again like you would pay for rent out of your pocket, private pay, or you again may qualify by having income and assets that meet public program eligibility, and one of those programs would be housing support. It's formerly called group residential housing. So there are some important reasons for why this system was created this way. The first was really to allow for choice and control over your providers. So a person could live somewhere and choose to get services from a provider other than their landlord. Well, what we found out is that that generally doesn't happen, that there's some type of relationship between the housing provider and the service provider, and that there aren't many services that are brought from the outside into a housing establishment. Another reason why the system was created this way is that it matches how we pay for assisted living type services. Our programs are separated in those that pay for room and board, those that pay for the actual physical building, and those that pay for the services that you receive in the building. So it makes sense to have this split system. And then lastly, our public programs, as a result of that payment, support this. The idea that you can receive your room and board paid for by housing support and your services paid for by elderly waiver. Unfortunately, this really caused confusion for consumers and regulators, which sometimes resulted in the lack of oversight and some questionable practices in marketing. There was no guidelines to really define what assisted living is, especially related to dementia or memory care. And all of that is now clarified, and I'm going to go through that in the rest of my presentation. So the new license goes into effect on August 1st, 2021, and it offers two options. The first is assisted living, and the second is assisted living with dementia care. Currently in Minnesota, we have a registration called Housing with Services Establishments. There are 2,446 housing with services establishments in the state. These are typically what we think of when we think of assisted living. Currently, 2,005 of these have submitted a conversion application to become an assisted living facility in Minnesota as of August 1st. 354 are in queue at the Minnesota Department of Health, waiting for them to pay for their license fees. And 858 of them have confirmed payment. So this is huge numbers. Think about the shift in almost 2,500 agencies are now shifting to a licensure framework. And it can be a bit of a confusing process, and it can be confusing for the residents who are living in housing with services establishments. And hopefully today I'll be able to clarify some of what's going to happen. So an assisted living license is required for any setting providing sleeping accommodations and assisted living services for one or more adults. So what exactly are assisted living services? Well, these would include any provider that offers assistance with activities of daily living. There are 5 activities of daily living. They include bathing, dressing, transferring, toileting, and eating. Services that also require a license would include any that provide some type of medication management, helping set up or distribute medications to residents, helping with mobility or transfers, any type of treatment or therapy services that are provided, if a provider offers healthcare services, or if they offer modified diets like mechanical diets or any other type of liquid diet, any provider that offers tube feeding, or any that offers supportive services. So if you or your loved one lives currently in a housing establishment that offers any of these services, that housing establishment may have to convert to the new assisted living license starting August 1st. So there are some settings that are specifically listed in the statute that are not considered assisted living. And what's really important is that these settings cannot call themselves assisted living anymore. They may call themselves assisted living now, but because there is a very specific license and it defines what assisted living is, entities that are not licensed cannot use the phrase assisted living in them. It's very similar to nursing home. A nursing home is a very specific license in Minnesota. You can't offer open senior apartments and call yourself a nursing home without having that Minnesota Department of Health nursing home license. So the different settings that are exempt from the assisted living law include private homes of related persons living together. What does that mean? That means many of us today here this morning. So my home, if my parents were to live with me, would not have to get an assisted living license. So every once in a while in law, it becomes very logical, and that is very logical. None of us have to get a license just to care for our own family members and our friends in our home, right? The second one would be adult foster care or transitional housing. The most common type of transitional housing would be something like an emergency shelter. Many of you may be aware of adult foster care. These are typically homes that are in the community that care for 4 or fewer adults, they look like small homes themselves. They will continue under their current regulatory framework. They already are registered and they have their own relationships with both the Department of Health and the Department of Human Services in Minnesota. If you live in an owner-occupied community like a cooperative or a condo where you own a stake or you own a private unit and then shared spaces, these are not considered assisted living. Any of the entities that are federally financed through a program that are offered, for example, through HUD, the Department of Housing and Urban Development, do not have to be licensed as assisted living. And that is one of the cases where federal law trumps state law. So the state cannot apply their specific regulatory requirements to these federal units that have to follow federal law. And then lastly, if you live in independent senior living that offers no services, no coordination of services, you are renting an apartment or a unit, this likely will not have to get an assisted living license. There are some exceptions to that, and it's important for anyone who operates independent senior living to check with the Minnesota Department of Health and understand your obligations to be licensed as assisted living or not be licensed. So the first thing that I want to talk about is the Uniform Consumer Information Guide, and we'll be sure that this is posted on the website. One of the major barriers as a consumer looking for assisted living is that you aren't able to compare apples to apples. You're not even really able to compare apples to oranges. You're like comparing apples to baseballs. They're so different, assisted living. And so what the Uniform Consumer Information Guide, which is listed in State Statute 144G, .06, is that you now will have an actual form that lists all of the services that the assisted living provider will offer. It will also list what the different payer sources are related to that service, and then any comments about the service, so if there are limitations. So you can use the Uniform Disclosure of Assisted Living Services and Amenities to compare different assisted living facilities, trying to get more to that apple to apple. We're probably still at comparing different types of fruit, but at least we're in sort of the same type of thing comparison. So I just want to read something from the Department of Health that I think is applicable. So prospective residents and their families can use the Uniform Disclosure of Assisted Living Services and Amenities tool to determine if the assisted living facility can meet their needs, allow them to compare options among various settings, and make informed decisions about selecting an assisted living facility. The information that is on the guide is important for a resident's ability to age in place. Assisted living facilities are not required to provide all of the services, so the actual disclosure that I have here is 19 pages long and can be quite overwhelming. And an assisted living facility, as I said, is not required to provide them all, and that they may be subject to change, but that the facility on this form will indicate which services are provided and any limitations, like if you can only get it during certain times of the day or certain days of the week. But the Department of Health also offers some other information for consumers. You're encouraged to tour facilities, talk with other residents, family members, or meet one-on-one with facility staff during the selection process. The disclosure itself is not a substitute for the contract that you're going to be signing. It's a separate document, and that document will then list the specific services that you've agreed that will be provided to the resident and any fees that are included in that service. So again, this is an really important step forward in helping consumers be able to make informed decisions about assisted living and where people want to live and what services they want to choose. There we go. So, like nursing homes, assisted livings will have a comprehensive survey looking at care, finances, and the physical plant. These surveys will occur every 2 years. The Minnesota Department of Health will conduct these surveys, and they will provide no notice to a facility prior to them showing up. You will hear perhaps in an assisted living facility people talk about being in their survey window. If you've ever had a loved one live in a nursing home or stayed in a nursing home for a short-term rehabilitation, you may have heard staff talk about the survey window, or you may have been a participant in a survey. Essentially what happens is a team from the Minnesota Department of Health will come to the assisted living facility over a course of time. It may be a day or several days, depending on what their findings are, how big the facility is, how many residents and family members they'll interview, and how much care they'll actually watch being provided. The survey team will take detailed notes. They will note different instances where perhaps a law wasn't followed or inaccurate or inappropriate care has occurred. One thing about the survey process is that in general, it's meant to ensure that a facility follows state guidelines. It is not necessarily there to applaud the facility for the good care and good work that they're doing. Facilities can do that by having very few notes. They're called deficiencies. So if a surveyor finds that someone is doing something wrong, they do what's called a tag. They assign a tag. That tag basically corresponds to the state statute, and it says something like, for example, this resident wasn't offered the assisted living bill of rights. So you receive a tag for that, and you're cited as having a deficiency. Many facilities have a deficiency-free survey, or they have very few deficiencies. Those are times to really celebrate, to thank the staff that are working in the facility, who over especially the last 15 months have been working very hard to try to mitigate and eliminate the COVID pandemic as much as possible in our senior care communities. So it is important when you do have a very positive survey to ensure that families and residents are aware of that, and that families and residents really understand that is sort of the applause from the Department of Health. What you're going to find is a correction order that if any of those deficiencies were found in the survey, the facility needs to develop a plan of action to correct whatever that deficiency was. And then depending on the deficiency, there may be a follow-up survey to make sure that that deficiency was fixed. This happens particularly if there was something egregious or really, really bad happening in the facility that affects a lot of people. The Minnesota Department of Health will go back in with their survey team and resurvey. So if there are problems found in a facility, they often can have violations and fines. So for example, if there were issues with something happening in dietary, if there was a deficiency, the Department of Health could subject the assisted living facility to a fine to pay for not following that rule. And the Department of Health can go so far as to take away an entity's license so that they cannot admit any new residents, depending on how bad, how egregious the surveys were. So again, the survey process is really meant to ensure that a facility is following state regulations. It's not necessarily designed for the Department of Health to go in and necessarily applaud the facility, but it is important to recognize when a facility has had a good survey, perhaps deficiency-free or a low number of deficiencies, that you do take time to applaud the residents, the family, and the staff that work in the facility, because it is a community. Just going to check here to make sure about any questions. An interesting question we've had come up regarding the vaccination requirements. Are all nursing home or assisted living staff required to be fully vaccinated from COVID-19? Currently, there's no federal or state law that requires anyone working in senior care to be fully vaccinated from the COVID virus. There has been just recently, I believe last week, the federal government clarified that an employer can require their employees to be vaccinated. It was a bit of a gray area because currently the COVID vaccines are being used under a special exemption in federal law for emergency use. And so because they are emergency use, not all of the same laws can apply to those vaccines. So the COVID vaccine, any of the regulations that would normally be under, say, a flu vaccine or a TB test, a tuberculosis test. If you've ever worked in a facility, I'm sure you've gotten a little needle under the skin, a Mantoux test to make sure that you do not have tuberculosis. Those things can be required because they don't have this special exemption for emergency use. We won't know if employers or facilities will require the COVID-19 testing. As I said, it's only been clarified recently, but something to really be aware of. What's very important is that if you have a loved one living in a facility, to ensure that that loved one has received their vaccine. When a person perhaps gets COVID after a vaccine, very often they don't know that they have COVID because there's no symptoms. It's a very mild case. For most people, if you get the vaccine, you will not get COVID. But as I said, for those who do perhaps get COVID, if you're one of the very, very few people, if you have had the vaccine, your experience with COVID will be completely different. So very important for residents to get that COVID vaccine. Another question that we had come up that was relevant to a slide I recently said is, do group homes fall under these new guidelines, such as for people with severe and persistent mental illness? That is a great question, and group homes are actually very much like assisted living. So as I mentioned, assisted living in Minnesota is kind of right now really nothing. We use the term assisted living just to describe housing that offers services primarily to older adults, right? And starting August 1st, we now will have a very specific definition of assisted living. That is the same for group homes. Group homes is a term that is used by the public to talk about different, very often small housing establishments that primarily serve people with disabilities, either people with intellectual and developmental disabilities, or a brain injury, or severe and persistent mental illness. Those organizations may have to get the assisted living license. It depends on if they fit any of the other criteria and they're not, for example, an adult foster care. Many group homes are classified as adult foster care, and as we saw on an earlier slide, adult foster care is exempt from the assisted living law. You will continue to be adult foster care. But for example, if you are an apartment building that has 10 people, and you offer assisted living services, you may have to become licensed as an assisted living facility. So I truly do not mean to dodge the question and not give a definitive answer of yes or no, but it really depends on what the current facility is, what services they offer, if they are going to have to be licensed in the future as assisted living. All right. So another question, just to clarify on my vaccine question, you said that there was a new regulation recommendation last week regarding employers requiring the COVID vaccine. And then I briefly mentioned testing as well. Are these both allowed to be required and mandated? So there's a difference between the vaccine and the testing. For the vaccine, currently in Minnesota, I'm not aware of any providers that are requiring the vaccine. The federal government only recently said that employers can require it. So we may see over the next few weeks or the month a requirement. Now, there are obviously many workforce implications for this. People may not want the vaccine for whatever reason, and if you already have a workforce shortage, you may lose more workers. We are in a very severe workforce shortage in senior care. That's very different from testing. Testing can be mandated, and in fact, testing is required if you fall under certain requirements. If your county has a certain percentage of active COVID cases, automatic testing occurs. So vaccines and testing are two separate things. All right, let's move on to the next slide, and then I'll come back to questions. There we go. There's been a lot of conversation about staff training to ensure that the people that are working in assisted living facilities are actually well trained and competent in providing services. So there are staff training guidelines in the state statute, and they're also outlined in some of the rules. One of the important considerations is that there isn't a number listed in state statute. And there's a very important reason why there isn't a number. Your facility must have this many people working as staff. It's because assisted living still will be very, very diverse. You could have buildings with several hundred people. You could have buildings with 10 people. And you could have an assisted living facility that specializes, say, in Parkinson's disease or memory care, or an assisted living facility that specializes in people with physical disabilities. And so what the Department of Health and the state legislature has said is that you must, as a facility, develop a staffing plan that meets the requirements of the people that live in your facility. So for example, let's say someone lives in your facility, it's a very small facility, let's say there are 6 people there, and one of the people requires 2 people to be transferred. Because of their physical disability, it requires 2 staff, 2 aides to transfer that person in and out of bed and helping them be mobile. If you are only scheduling 1 person on an overnight shift, you are not meeting the staffing requirements of the residents that need care in your facility. You must schedule at a minimum 2 people overnight because you have a person that lives in your facility that requires 2 people to transfer. So that's basically what the staffing plan talks about, is that staffing levels must be consistent with your care. When we're talking about training, initially an individual needs to receive training on an overview of the assisted living laws, any policies and procedures that the facility uses, any emergency handling. So depending on what happens during an emergency, what are staff mandated or required to do by your policies. They must understand the vulnerable adult law, which I talked about earlier. When do you report maltreatment? How do investigations occur? The Bill of Rights, which I'll talk about in a little bit. Person-centered planning and services. Handling of any complaints. Consumer advocacy services, so this would be an organization like the Ombudsman for Long-Term Care, which I'll also talk about in a couple of minutes. The person should also have a basic understanding of aging, hearing loss, dementia, falls, technology, isolation, and depression. And lastly, there are additional training requirements for those assisted living facilities that have the additional assisted living with dementia care license. Remember, one of my first slides talked about the new assisted living license as essentially being 2. You are either an assisted living or an assisted living with dementia care. And what's really important to understand is that if a person moves into an assisted living facility and over time perhaps they develop some form of dementia or they begin to experience memory loss or other cognitive impairment, that doesn't mean that that assisted living facility has to kick them out and move them to an assisted living with dementia care. It just, because the whole idea is to help people age in place, right? That assisted living facility may still be able to provide those important services to help that person age in place. However, if an assisted living facility does not have the dementia care license, they cannot market themselves as memory care. I'm sure many of you driving around and doing web searches have seen assisted living with memory care. In the future, only entities with the actual assisted living with dementia care license will be able to call themselves memory care. But again, to clarify, if a person living with memory loss in a licensed assisted living facility, they do not have to leave that facility as long as the facility can continue to provide competent and good services to them. Going to jump back to any questions here. Okay, I'll go forward. So I talked about the staffing levels. This is a quote directly from the statute. Staffing levels must be sufficient to meet the scheduled and unscheduled needs of residents. Staffing levels during nighttime hours shall be based on the sleep patterns and needs of residents. So all assisted living facilities will be developing a staffing plan and they have to follow that staffing plan. And this is where the survey kicks in. Every 2 years, a survey team will come out and look at their staffing plan. They will ensure that the staffing plan has been followed so they can look at employee timesheets and records to audit to make sure that if, for example, you say that you will always have 2 staff on site, they can go and flip back 6 months and on a random day, you know, Saturday at 2 in the morning, and they can make sure that that timesheet shows that there are 2 people that were in your facility at that time to be able to care for the residents. In addition, there are going to be substantial changes to the physical plant requirements. Assisted living must now adhere to what's called the Life Safety Code. The Life Safety Code is a very, very thick book. It's the book that often scares my students that are part of the nursing home or assisted living program the most, because it's pretty thick. But it talks about all of the different construction requirements and accessibility requirements for all types of buildings. So for example, the public building that I'm in now may have to meet some of the construction requirements that are outlined in the Life Safety Code. Schools have to meet requirements in the Life Safety Code. So there are many, many chapters. And one of the chapters is related to healthcare settings, whether they're existing construction or new construction. And for those of you that are looking at assisted living facilities, it's very important to understand that the rules and laws may be different based on whether or not they are new construction or existing construction. So if you look here, this quote, all assisted living facilities with 6 or more residents must meet the applicable provisions of the most current edition of the NFPA Standard 101, the Life Safety Code. Residential Board and Care Occupancy Chapter, and the minimum design standard shall be met for all new licenses, new construction, modifications, renovations, alterations, changes of use, or additions. This is pretty significant since many assisted living facilities may be that smaller home. They really need to think through accessibility guidelines and if they meet that Life Safety Code. So not only did the physical plant and services receive new requirements, but so did everyone that's operating an assisted living facility. In fact, there is a new assisted living director license. So there are 3 ways that you can become an assisted living director. The first is if you are a current licensed nursing home administrator, you automatically can get the assisted living director license. I fall under that category. I received my nursing home administrator license and just last month received my assisted living director license. If you are a new licensee, so let's say you decided that senior care is your passion, you want to operate an assisted living facility, you want to become a housing director at an assisted living facility, you have to do essentially 4 things. One is that you have to complete an accredited training course. And as I mentioned, we offer that course here at the University of Minnesota. There are 2 other courses that I know of currently offered by our 2 partners in the trade associations of Care Providers Minnesota and Leading Age Minnesota. You must also participate in a mentorship with a licensed assisted living director. And that mentorship can be anywhere around 300 hours to 1,000 hours, depending on your experience working in assisted living. So for example, if you were a nurse working in assisted living, you may not have to have a very long mentorship because you have that experience of being in assisted living. But if you've never worked in assisted living, you may have to have a 1,000-hour mentorship with a licensed assisted living director. And then the last component is 2 parts. You need to pass 2 exams. One is a state exam on all the regulations that I've been talking about, and another is a national exam that is offered by the National Association of Long-Term Care Administrator Boards, affectionately known as NAB. It is an online exam that covers really being a director or administrator of various senior care settings. There's a core part to exam, and then there's 3 different modules, and you can select which module you need. There's a nursing home administration, a residential care and assisted living, and then finally a home and community-based services for home care and hospice. So an assisted living director has gone through a training program, participated in a mentorship, and passed 2 exams, a state regulation exam and a national exam on running assisted living and residential care. For the next couple of weeks, recognizing that there are a number of people that have been operating assisted living facilities very successfully for a number of years, there is what's known as the legacy pathways. Essentially, if you meet different criteria, like you've been a director of an assisted living facility for a number of years, you have a degree that relates to assisted living director or senior care, you can get a legacy license, again, only through June 30th of 2021 by applying through the state licensing board. That means that you don't have to do the training or pass the 2 exams or the mentorship because you have proven that you have the experience and you have the education. So that's sort of what there is related to the assisted living director. The assisted living directors will be under the auspices of the Board of Examiners for Long-Term Services and Supports. We call them BELTS. And BELTS is the state agency that licenses nursing home administrators as well as the new assisted living director license. So, what are some of the consumer protections that are in the new law? This is a very important part for family members and friends and residents of housing with services, soon to be assisted living. The first is a Bill of Rights for assisted living residents, and we'll be sure that both the Bill of Rights and the Uniform Disclosure are included with the PowerPoint slides in our conference library. The different boxes that you see on here may be very small. My notes are extremely small. You may not be able to see them. I'll hold them up. So it will be a little difficult to read them all. But I wanted to show you that the Bill of Rights is an important document because it outlines many of the consumer protections that residents of assisted livings and family members have. I do want to read the beginning from the Minnesota Department of Health just to give you an idea. Before receiving services, residents have the right to be informed by the facility of the rights granted under this section and the recourse residents have if rights are violated. The information must be in plain language and in terms residents can understand. The facility must make reasonable accommodations for residents who have communication disabilities and those who speak a language other than English. When providers violate the rights in this section, they are subject to fines and license actions. And so many of the rights are things such as appropriate care and services, the right to refuse care, participation in care planning, the right to come and go freely, the right to control your resources, courteous treatment for visitors and social participation, confidentiality, personal and treatment privacy. You have a right to furnish and decorate your unit within the terms of the contract, the right to choose a roommate, to access food, to access technology at your expense, the right to counsel and advocacy services, to information about the charges, and the right to a resident council and a family council, which I'll talk a little bit more about. So if you are a resident of an assisted living facility or a family member, or you are going to become one, you should know that you will receive a copy of the Minnesota Bill of Rights for Assisted Living Residents, and you will have to sign that you received a copy of the Bill of Rights, acknowledging that receipt. I wanted to touch very briefly on electronic monitoring, but before that, I'm going to see what kind of questions we have. It looks like a few have been coming in. If a facility does not accept a two-person transfer and a resident admits and later requires a two-person transfer, they would have to move, or does the facility have to make adjustments to provide care? So in general, if the facility cannot provide that care, they would have to work through a discharge plan, and I'll be talking about some of the protections in a discharge plan. That facility may be interested in increasing services and able to do that, but an assisted living facility is not required specifically to provide certain services. Are private home healthcare services required to follow the guidelines that are required by the assisted living facilities? Private home health care services that go into an individual's home are required to follow the home care license that is already in effect with the Minnesota Department of Health. So there are different levels of a home care license, and they're already regulated. What may happen is that a person lives in a housing with services that has a separate home care entity, but that home care entity is owned by the same company that owns the building. Currently, that would be required to obtain an assisted living facility license because they're owned and operated by the same entity. So you may see some changes from a comprehensive home care to an assisted living license. And it's important for you to keep in contact with your facility to understand how they're transitioning and where they're at in transition. Because again, you may have a home care bill of rights and an entity may be regulated by a home care agency, particularly if you live in an independent apartment that offers no services and you bring in your own home care agency, that likely would not fall under the current assisted living license. It would fall under the either comprehensive or other home care license. So someone did ask about the private pay requirements prior to applying for elderly waiver or the CADI waiver. The elderly waiver and CADI waiver are programs that are available for people who qualify for our medical assistance, our state Medicaid's program. So they're very low income, low assets to help them pay for services to remain independent in the community. I won't be talking too much about that. Essentially, I think what the question relates to is sometimes a facility may require you, they may only have a certain number of units related to public programs, and so a person enters a facility private paying, and then they've paid their income and their assets, they've spent them down and now qualify for elderly waiver or the CADI program. This will be specifically outlined in your contract and the uniform checklist disclosure, whether the facility accepts elderly waiver or the CADI program. The service that they offer is called customized living, so it's really important that you understand the rules and regulations and policies of the individual facility as it relates to the different public programs that they accept. The right to come and go freely, does this pertain to assisted living with dementia care? That is a great question, particularly the topic of our conference. There are specific regulations related to how an assisted living with dementia care implements their physical plan. Assisted living with dementia care can still have secure wards. They have to do things like hazard assessments. So a hazard assessment is an assessment that a professional does to look at the safety of an environment to ensure that a person, in this case with memory loss or cognitive impairment, the risks are minimized for them to be injured or even perhaps die. So the idea of the right to come and go freely for a person with dementia care would be for a person with dementia or memory loss would be included in that individual's care plan. So for example, if it is allowed in their care plan that a family member can take that resident out into the community safely, that would be the freedom to come and go freely. But at the same time, if a person does have memory loss or cognitive impairment, there are these secure units so that a person who may have wandering behaviors doesn't just go out of the facility in an unsafe environment. So there are limitations to this idea of come and go freely, but a person should still be able to leave a facility if they have memory loss or cognitive impairment, as long as they have the appropriate supervision to ensure their safety. How would choosing your roommate work? Well, every facility does it a little bit differently. Some of them do sort of kind of roommate matching. Sometimes it really is sort of this is the unit that is available right now. When working in nursing homes, some of the biggest arguments often are roommate switches because someone wants the window open and someone wants the window closed, or someone listens to their TV. Assisted living are really going to have to learn, and I think they do a good job at ensuring that many of them do a good job at ensuring that residents get along, they meet one another, and you have to develop those rules. When you live in a communal setting, you have to come to those agreements that, you know, at 11 o'clock, we need to make sure that our light in our bedroom is off because I'm going to go to bed, and those types of things. So it's a complex navigation. If you are unhappy with your roommate, the facility does have to help. They have to help you troubleshoot and problem solve any roommate issues. But it's not just as easy being able to say you can choose whoever you want to live with, though it is listed in the Bill of Rights. Let's see. I think that's where we're at with the questions right now, so I'll come back to more. You can keep them coming. So I want to talk a little bit about electronic monitoring. This is written in state statute and actually already went into effect. Electronic monitoring is sometimes informally referred to as granny cams, or the ability for you to put a recording device in someone's room to be able to record the actions of the people, the staff and volunteers that are helping that person. This not only applies to our assisted living that will go into effect on August 1st, it applies to the current housing with services. So the current, if you live in assisted living right now, it likely applies to your setting, and it also applies to nursing homes. Basically, the law clarifies that a resident can install a monitoring device in a room. And this legislation is very well worked out with consumers and providers, and it's actually a model that many different states are looking at. The resident can install a monitoring device, but there are 3 stipulations. One is that it requires consent. A family member cannot install an electronic monitoring device in a resident's room without that resident's consent and without the roommate's consent. You also must provide notice to the facility that you have installed a recording device. If you suspect that there is some type of maltreatment going on, you can install a device for a very short window without telling the facility, but you must inform the Ombudsman for long-term care. You then will have 14 days to use that electronic monitoring device without informing the facility. So again, you have to notify the facility, but if for some reason you believe that there's maltreatment occurring, you can install a device and have a 14-day window where you don't have to tell the facility, but you must inform the Ombudsman of long-term care that you've installed that device. All right. One of the very sad happenings that was outlined in the Left to Suffer series by the Star Tribune was the fact that there were instances where some residents had died and they were not found in a very timely manner. And so one of the requirements in the new legislation, 144G.08, is an I'm okay check services. So an I'm okay check services means that an assisted living facility needs to have, maintain, and document a system to, by any means, check on the safety of a resident a minimum of once daily or more frequently according to the assisted living contract. So for example, if a person perhaps is experiencing early stages of dementia, has perhaps some forgetfulness, is fairly independent, perhaps in the assisted living contract, there must be 3 check-ins during the day and 1 check-in at night. That would be what the I'm okay check needs to adhere to. But in general, you must be checked on at least once per day. So there's also information in the statute about coordinated moves, also referred to as discharge. There are 4 primary ways that a person can be discharged from an assisted living facility. One is non-payment. A second is non-compliance with the contract. The third is that the facility can no longer meet your needs. So we had a question earlier about someone perhaps whose physical disability has progressed to a place where they need 2 people to transfer and the assisted living facility is not able to provide that. That could be justification for discharge to another facility because they can't meet the needs of that individual. Or if a person is endangering to others. If discharge is occurring, the facility must attempt to resolve issues before any discharge occurs. They must let a resident back after a short hospital stay. The resident has appeal rights for any discharge or coordinated moves. There also must be a plan for discharge. And lastly, if a facility is not renewing a lease, that facility must provide a minimum of 60 days notice to an individual that they will be discharging them. We have a question. So where can a person go if they are endangering to others? Could they be medicated? So a 2-part question. There are some facilities that have specialized training for people that may have behavior issues that may be harming to themselves or to others. It may be more intensive one-on-one supports. It may be some of the more secured units. These are services that you will be able to identify in the uniform disclosure of services if they are available. I think it's very important for you to be clear and upfront about the services that are needed to people who self-harm or harm others, because it is a reason for discharge. There is a question on medication. So you can't, in most instances, medicate a person as a form of subduing them. You can't offer medications to, make a person tired, or you can't force medications on a person to change their behavior. A person, regardless of what setting you're in, you have a right to refuse treatment, and that includes medication. Even for people that have very severe and persistent mental illness, you can't force someone to take medication. Now, a court could order in some very rare cases. Unfortunately, we see a lot of these cases, you know, perhaps on things like Law and Order and other television shows, but in general, you know, a court is not going to necessarily order medication unless a person is at risk of harming themselves or others, and then it would be under strict watch of some type of guardian, a court-ordered guardian or other. So for this question, which may not be sort of the best answer and could be frustrating to you, and I understand that if you're working with someone who has some behavior issues, that because of their memory loss, dementia, if they have you know, Lewy body or some other dementia that may have some additional behavioral issues with it, it's really important for you to be clear with providers and to understand what services they can offer, and to when appropriate, accept that a person may have to move because it's not the right facility for them. So I hope I answered that question well. So in addition, in the statute, there was an expansion of our ombudsman for long-term care in Minnesota. Minnesota, we are consistently ranked as being top in services for older adults. They're often called long-term services and supports. Once again, we got #1 in the national rankings. And ever since they've been doing the scorecard, we've either been #1 or #2. And so that's definitely a kudos to the hard work that our state government and our providers are doing to ensure that there are services and supports in place for older Minnesotans and their friend and family caregivers. However, one area where we really needed help was our Ombudsman office. So for those who don't know what the Ombudsman office is, the Ombudsman is actually a word that comes from Sweden, which is very appropriate for those of us in Minnesota. And it basically means king's men. And the Ombudsmen were people that the king would send out into communities to hear directly from the people, to understand what their needs are. You know, sounds like a very good king, a very good ruler, to hear from his subjects how best he can govern and rule. So the Ombudsman is very similar. We have very different types of ombudsmen in Minnesota for different populations. And the long-term care ombudsman is an advocate for individuals that reside in nursing homes and other licensed and registered settings. The ombudsmen have special abilities to be able to go into facilities and do their own client interviews and look into issues and problem solve. Often a provider may call an ombudsman to help out, to understand a resident's rights and what they can do to support the people that are living in their facilities. But also a family member or resident may make a complaint to the ombudsman office, who will send out an ombudsman or an advocate to look into how things are going and help explain and clarify different laws and regulations. So we were very happy that in this legislation, it provided funding for 17 additional staff for the Office of Ombudsman for Long-Term Care. We were sort of towards the bottom of the pack in states for our number of ombudsmen per residence. And so we've increased that, we've increased the number of ombudsmen, decreased that ratio pretty significantly, hiring another deputy ombudsman, regional ombudsman for many of our outstate areas, an electronic monitoring coordinator, and then some additional administrative staff. When you're doing investigations and working with people, it is so important for you to track well the conversations and what has occurred, because as many of you who live in assisted living and are family members of people that live in assisted living, these are your lives and they're important. Your rights are very important. So this administrative staff is very important in the ombudsman work. So many facilities will not allow a patient to return to the assisted living after a psychiatric hospitalization and say they cannot meet the needs and therefore do not give a 30 or 60-day notice. Will they be able to do this? So this does come under whether an entity is able to provide services or not, and it could be a reason for discharge. So again, the answer can be both yes and no. A person who is discharged because a facility cannot provide those intensive geriatric, psychiatric services do have to have it well documented and need to prove that that is true. That's one of the differences in what's happening today. Many facilities don't have to have the comprehensive documentation. Many do. Many do track all of this information in case and care plans. But in the future, they still are able to discharge because they're not able to provide services. But it must be clearly documented that they cannot provide those services. Great question about how did the Office of Ombudsman come about. They have a long history in actually across the United States. Here in Minnesota, they are housed within our Department of Human Services. And maybe we can schedule a future webinar. We'll put that on our list to invite one of the ombudsmen specifically to talk to family members and people that are living with memory loss to talk a little bit more about how the ombudsman can help you. So we'll be sure to make note of that, and perhaps that's part of my role as the Associate Director of Education. I need to, in my duties as assigned. So thank you for that question. I wanted to touch briefly on the assisted living report card. So when you are looking for a nursing home, you are able to go to medicare.gov and look at the Medicare Compare website, where it compares nursing homes on a number of indicators that really come from surveys. So it's very sort of regulatory compliance. And the idea is you could compare nursing home A to nursing home B, see how many of them had good surveys or poor surveys. In Minnesota, we took that much deeper. We have a nursing home report card that not only looks at those regulatory requirements, but also looks at other quality of life indicators, including interviews with families and residents, and other qualitative information that's obtained through different processes. We are working to replicate that to create an assisted living report card. And that, I think, will be another great future webinar. Perhaps it's a webinar on the Ombudsman program and the assisted living report card. My colleague in the School of Public Health, Dr. Tatiana Shippey, is one of the lead researchers on this effort. Essentially, the state provided funding to our Department of Human Services to create a report card to measure quality in all settings, regardless of their payer source. And essentially, the report card will offer quality of life indicators. It will talk about experiences of residents in the assisted living facility, different healthcare outcomes that again can come from some of the survey processes and different payer sources, family satisfaction indicators, regulatory compliance. How did the surveys go for a facility? How many deficiencies did they have? How many investigations have they had outside of the survey process? And then different workforce and workplace indicators, such as the number of staff, the turnover in staff. And so the Department of Human Services is working with our University of Minnesota School of Public Health on different measure development. And this is really charting new ground. Even though there have been various quality indicators and a lot of research on quality in nursing homes, the same is not true for assisted living facilities. There is very little research talking about specific quality indicators in other senior care communities. So Dr. Shippey and her colleagues in the Department of Human Services have had to do a lot of comparison with other senior care communities, looking even outside the United States, and really testing different measures to ensure that they will be helpful for families and individuals who are looking at moving into assisted living. If it is required that assisted living provide adequate staff to meet the needs of residents, but also can discharge people because they cannot meet those needs, how does that work out in reality? Does this mean that facilities are only required to meet the needs of people at the point they are initially admitted? That is a really great question and very complex. So if a person has a disease that is progressive or degenerative, it changes over time, the reality may be that that assisted living facility cannot care for the person in different stages of the progression of living with that disease. And that currently happens now. At times, a person may no longer be able to live in an assisted living facility and needs to move into a nursing home. The difference is all of this now is extremely transparent and documented. There has to be a care plan that explains that. There has to be very specific rationale that says, you know, this person has wandering behaviors. We are not a memory care. We provide assisted living services. We specialize in providing help for people that have physical and mobility disabilities, not cognitive disabilities. This person now has significant behavior issues, wandering issues. We don't have the staffing that are trained or prepared to help this person age in place. We need to find other services for them. But again, it's happening now. It will continue to happen that people will need to be discharged if a facility is not able to provide those services. But it is transparent and you have rights and you understand the process that a person is discharged, and there's a plan that perhaps that facility helps find another facility to discharge to that has the specific knowledge and expertise and staffing to help that person. That's the discharge plan. Which doesn't necessarily occur now. Some facilities definitely do that. They do a good job of that, particularly those perhaps that are part of a campus setting where you can move through different levels of care. It's not going to stop the fact that sometimes an assisted living facility can no longer provide services, but it is going to be transparent when they can't, why they can't, and what they're going to do because they can't. Go back to a couple more questions here. Is there anything in the bill about adult day centers and how they are doing now that people have been vaccinated? So adult day services are an important role in the lives of caregivers serving as respite care. There is nothing in the assisted living bill that particularly talks about adult day services, and there currently isn't anything that specifically talks about COVID in adult day services. I think you're going to see more and more adult day services providing services as long as people are vaccinated. I know some adult day programs have been trying really hard to help engage people at home, which can be very difficult, particularly for caregivers who are experiencing sort of that book that many of you may have read, that 36-hour day where someone has lost their night-day rhythms and are experiencing extreme burden and stress and burnout. But there is nothing in the current license laws that talk specifically about the adult day and vaccination. So I wanted to talk a little bit about the implementation timelines. I think one of the most important things to remember is that prospective residents must call the senior linkage line to discuss their housing options before signing a contract with a licensed assisted living facility. The senior linkage line, which is 1-800-333-2433, is a helpline that caregivers and older adults can use to really navigate services, to understand things about Medicare and medical assistance. But in addition, they have a role in helping people understand their right to age in place and the services that are available. This is under current law and it will not change under the future law. You still will have to contact the senior linkage line prior to moving into assisted living and signing that contract. So a little bit about the assisted living implementation. This is just a little chart. Some people really love charts. table looking at the different years of implementation. So you can see some of the things have already been in place, like retaliation protections, the rulemaking, the assisted living director rulemaking, and the convenings for the report card. In 2020, we had the electronic monitoring and a quality improvement task force. In 2021, this is where July, coming up in just under a month, the director license will begin. In August, the new license, the retaliation protections in the new license, the I'm okay checks, the discharge protections all go into effect with that new license. Beyond, there are physical plant requirements, so out even to 2029. And the reason why they are put out quite far is because if you are in assisted living with dementia care, there are very specific physical plant requirements that you're going to have to implement that may take substantial financial investment. For example, installing a fire suppression system. So installing a sprinkler system into your assisted living facility. That could cost you significant amount of money. And so this is giving you essentially a decade from when the license passed to be able to plan for that, that conversion. I wanted to say that over the last couple of years since the legislation passed, the Minnesota Department of Health has been involved in rulemaking. The pandemic greatly changed a lot of the work of the Minnesota Department of Health, where almost every staff were deployed to assist with the pandemic with COVID mitigation strategies. But rulemaking has continued, and these were a number of the areas that were not outlined specifically in legislation, but were left to rulemaking. If you're interested in a lot of the nuts and bolts of the rules, if you're a policy wonk like me, the Minnesota Department of Health hosts a weekly webinar, and you can access that webinar on their assisted living licensure website. If you just Google assisted living and Minnesota Department of Health, you'll get right to the website. The webinars are free to participate. I will say that they are very technical, and they're designed for providers who are becoming assisted living facilities. They're not necessarily designed for families and consumers, so it's a lot of technical language, but you might be interested just to pop in. They do post the slides from every one of the webinars, though they do not record the webinars themselves. So, that is the end of my presentation. I got a couple of minutes early. Let me just verify if there are any additional questions that I can answer. It looks like we are good. If I was not able to answer your question, or you weren't satisfied with the answer or want more information, my email is here. It's moon0060@umn.edu, and I am more than happy to answer any questions that you may have. I'm going to turn it back over to Dr. Gogler, who I think is going to take us to a little break before our next presenter. So, Joe.
Well, thanks so much, Dr. Moon, for that very timely and really relevant presentation for all of us. There are going to be major changes happening to the residential long-term care environment and assisted living, as Rajan so ably described. And I think all of us being aware of them, being prepared for them, is going to be critically important when we think about caring for people living with memory loss. So thanks again, Rajan, so much for your time this morning.